For me, I have made that argument so clearly. I tried my best to make it so clearly that they didn't take into consideration those saving clauses. And you can see that in other provisions where there are saving clauses in the judgment, they took very serious consideration of them and they arrived at a conclusion. For me, I don't think the context of the Constitution, as they said, has warranted a departure from the provision that is linking Speaker to a presiding officer. Because, you see, a deputy speaker or anybody presiding is acting in the stead of a speaker. And there's a provision of the Constitution that says that anytime we mention speaker in the Constitution, we are referring to the person also presiding. But you see, the Supreme Court has come to the conclusion that no, that provision doesn't apply because in it, there is the word except or unless the context otherwise requires. And they went through the whole provisions of Article 95, 96, 97, and came to the conclusion, Chapter 10, and came to the conclusion that no, that context does not, requires that they don't call or they don't refer to the deputy speaker who is acting as the speaker, which means that every limitation, privilege, or right that applies to the speaker will not apply to the deputy speaker when he's presiding. I think I disagree with that because I think that the context rather reveals otherwise, contrary, because you see, it is the principle of objectivity and impartiality that the context revealed that the framers of the Constitution wants to project. If you look at it well, because you see, when the speaker becomes a speaker, he ceases to be a member of parliament. Now, if you look at, if we leave the speaker alone and go to the deputy speaker, you will find that if a minister or a deputy minister becomes a deputy speaker, under Article 81, he ceases to be a minister, which means that the Constitution doesn't want the deputy speaker, just like the speaker, to be a member of the executive. So you can see, so why would the Constitution prevent the deputy speaker from being a minister or deputy minister? It is because it wants to be, the Constitution wants him to be impartial because he would be presiding. And you see, to say that because there's an express provision relating to the speaker, excluding him from being, from voting or from having original or casting vote, but no express limitation on the deputy speaker, I think that also is erroneous.
All right. Now, if you can deal with this last one briefly for us, then we'll continue. You also, like others, impeach the Supreme Court, as it were, invoking its jurisdiction to strike down Order 109 of the Standing Orders of Parliament as being null, void, and of no effect. How so?
Yes, you see, first of all, I expressed concerns about the jurisdiction of the Supreme Court not properly being invoked in this matter. Because you see, we have looked at several cases and we have realized that even where the original jurisdiction is invoked in respect of interpreting some provision of the Constitution, if the provision of a Constitution comes up for interpretation which is not stated in the original rate, they decline interpretation of that particular, and I have cited several cases. But in this case, you can see that Justice Abdullahi never brought in any provision of law saying that it is inconsistent with any provision of the Constitution before the Supreme Court. Secondly, you could see that the interpretation of the Supreme Court is filling up a gap because they admit that there has not been any provision that limits the deputy speaker from being part of a quorum or from voting. So the same way, there's no provision giving him that right to count himself. There's no express provision anywhere that says that the speaker, the deputy speaker, should be part of a quorum or should have an original vote. And so we take it that this is a matter the Constitution hasn't provided for.
Okay.
And if the Constitution hasn't provided for it, I think the best place is the residual powers of Parliament, which is in 298.
Okay.
And so the Constitution confers on Parliament residual powers to deal with matters that it doesn't provide for, The Constitution, the Supreme Court has no jurisdiction to fill in those gaps. That's my point.
All right.